What happens when artificial intelligence can recreate one of history's greatest voices, but without his consent? That is the question that OpenAI is facing after users begin generating lifelike videos of Dr. Martin Luther King Jr. using its new text to video tool, Sora. Some clips were respectful, others were distorted, twisting his likeness and legacy in ways his family called disrespectful. And in response, OpenAI and the King estate released a joint statement announcing a pause on all Sora generations involving Dr. King. Their message stated in part, while there are strong free speech interests in depicting historical figures, OpenAI believes public figures and their families should ultimately have control over how their likeness is used. Authorized representatives or estate owners can request that their likeness not be used in Sora cameos. And this section of the statement captures the tensions we're living through between creative freedom and the right to control your own image in the age of AI. And that's what we're exploring today on Open Tabs with Attorney Danielle. Let's get into it. Hi, I'm Attorney Danielle, and I cover all things tech, policy, law, and culture. And today we are unpacking what the Sora controversy reveals about the future of digital likeness, consent, and the limitations of regulation in the AI age. So first, I want to discuss what the law actually says. For one, let us be clear. This situation is not a free speech case in the constitutional sense. The First Amendment stops the government from restricting expression. It does not stop private companies from setting their own rules on what they will and will not allow on their platforms. So when OpenAI pauses content or limits what Sora can create, that is a decision that they decided to make on their own. And more importantly, by doing this, OpenAI is not violating anyone's rights. They are exercising what we call platform governance. In other words, it's within their discretion to do this. But even considering that doesn't mean there aren't legal questions. Because even though OpenAI has a constitutional right to moderate what happens on their platform, individuals still have a legal interest in how their likeness or that of their deceased family member on occasions is used. That's where the right of publicity comes in. A state-level legal right that lets people, and in some states, their estates, control how their name, image, or voice is used for commercial purposes. So here's the catch. There's no federal standard. Every state does it differently. For example, California has one of the strongest laws in the country. It protects a person's likeness for 70 years after death. And under the new law, AB 1836, which was passed in 2024, now extends those protections to digital replicas, meaning AI-generated likenesses or voices of deceased individuals cannot be used for commercial gain without consent. Another example is Georgia, where Dr. King was born. It recognizes a common law right of publicity that can survive death, but it's not spelled out in a statute, and it doesn't clearly cover digital or AI-generated uses. And lastly, many other states either limit protection to living individuals or don't address the issue at all, leaving major gaps in how identity can be protected in the age of AI. So when an AI system creates a digital Dr. King giving a new speech, the legal questions become, is that creative expression protected by the First Amendment or an unauthorized use of identity? The answer depends entirely on where you live and who's making the decision. So now I want to discuss where the real tension lies. Because here's the real policy challenge. How do you regulate this space without violating the Constitution? Lawmakers can't simply tell companies what content to remove. That would risk government mandated speech control, which does raise First Amendment concerns. But it's worth noting that narrow transparency or labeling rules, like requiring platforms to disclose when content is AI generated, usually doesn't cross that line. Those kinds of regulations target consumer deception, not expression, and they can survive constitutional review. Still, if Congress or a state went further, say by ordering companies like OpenAI to ban all depictions of real people, that would shift from regulating conduct to regulating speech, and the constitutional red flags would start to fly. But on the other hand, leaving everything to corporate discretion means families and estates have little recourse when a person's likeness is misused or distorted. And that is the policy tightrope policymakers are walking. Think about it this way. Too little regulation and AI deepfakes can distort truth, history, and legacy. But too much regulation, and we risk turning private moderation into government censorship. The challenge isn't about whether companies can act, because they can. It's about whether lawmakers can craft rules that protect people's likeness and identity without crossing into state controlled expression. Right now, we are still in that legal gray zone, a patchwork of state level efforts and private policies with no federal framework to anchor them. So now I want to look at one state that's trying to get it right, California. Its new AB 1836 that I discussed earlier passed in 2024 and is one of the first laws to recognize digital replicas, aka AI generated likenesses or voices of deceased individuals, as a form of protected identity. But what makes California's approach stand out is how it balances rights. It doesn't police ideas or restrict creativity. It simply requires consent when someone's digital likeness is used for commercial advantage. So, in plain terms, you can't profit from a deceased person's AI generated image, voice, or performance without permission from their estate. But the law explicitly exempts journalism, documentaries, and parody, forms of expression that sit at the heart of First Amendment law. Because it targets use and profit, not viewpoint or message, the law is content neutral, focused on protecting people and not policing speech. That's why it survives constitutional scrutiny and why other states are beginning to follow suit. Now, California's framework isn't perfect, but it points to a middle ground, one where innovation can thrive, creativity remains free, and a person's likeness, even after death, still carries legal dignity. So now, let's bring this home. Could California's digital replica law actually stop what's happening with OpenAI Sora and the AI-generated videos of Dr. King? The short answer is partly yes, but not completely. And here's why. Number one, it could apply if certain conditions are met. If someone used Sora to create and distribute a new AI generated likeness or voice of Dr. King for commercial gain, say in advertising, paid content, or merchandise, and that use was tied to California, meaning that the creator, the platform, or the audience was located there, the King estate could have a strong claim under AB 1836. Because the law defines a digital replica in part as a computer-generated, highly realistic representation of a deceased person's voice or likeness used in a performance or communication they never made. And that is exactly what many of these Sora clips are doing, creating performances that never existed. So let's move to 2, where the law might fall short. Because AB 1836 is still a state law, not a federal one. Its powers stop at California's borders. And if the content is created, hosted, or monetized elsewhere, the law's reach gets murky. And because OpenAI is a global company and Sora users span multiple jurisdictions, enforcing California statute would depend on proving a California nexus, meaning that the wrongful act or harm occurred in California. It also only applies to deceased personalities. So if the same issue arose with a living person, say an activist or a political figure alive today, this law, AB 1836, wouldn't apply. Different laws would have to fill that gap. And remember, the law targets commercial exploitation, not artistic or educational uses. So if Sora videos are labeled as tributes, commentary, or political speech, they might fall under the First Amendment carve-outs for news, public affairs, or parody. The same protections that shield documentaries, satire, and artistic expression. So let's look at the bigger lesson. So yes, California's statute gives estates like Dr. King's a new legal hook to challenge AI replicas. But no, it doesn't yet create the kind of nationwide protection needed to stop these issues before they spread. But what this situation really highlights is how state-by-state regulation can't keep up with global platforms. And until Congress enacts a uniform rule for digital likeness and AI replicas, enforcement will depend on where the content was made and how creatively the lawyers can argue jurisdiction. So let's now discuss the bigger picture, which is policy and legacy. California may have drawn the first legal line, but one state can't govern a global problem. And that's the real takeaway here. Technology moves across borders, but state law does not. Generative AI has made it possible to resurrect, remix, and even reimagine history in seconds. And that power forces us to ask some uncomfortable questions. Like, one, who should control a person's digital likeness once it leaves the physical world? Two, what does consent mean when anyone can clone a face or voice with a prompt? And three, how do we protect legacy and truth without freezing creativity in place? And right now, there's no federal standard to answer any of these questions. That vacuum leaves companies like OpenAI writing the rules themselves, deciding what's ethical, what's risky, and what's allowed, all through internal policy rather than the law. So to close that gap, Congress will eventually need to act, but it has to tread carefully. Because the goal isn't to police creativity or silence innovation. It's to protect consent, context, and truth in a world where technology can rewrite all three. Well, guys, that's the end of this video. If you found this video helpful, make sure to hit the like button, subscribe to the channel, and tell me in the comments, should AI companies need a state consent before generating historical figures, or should expressive freedom take the lead? Let me know in the comments below. And also remember to check out my podcast, The Miseducation of Technology, on Spotify, Apple Podcasts, and right here on YouTube, because technology may have been miseducated, but you do not have to be. I'll see you next time on Open Tabs with Attorney Danielle. Bye.